before we begin, I believe Mr. Moa has some things that he would like to add to the record.
Very briefly, Your Honor. I want to move to admit Defendant's Exhibit 93, which is just a paper copy of the defendant's renewed objections regarding the exclusion of parts of Ranger Armstrong's testimony. I want to just make the record clear, although you did reference it yesterday, Your Honor, I want to make the record clear that this applies both to Ranger Armstrong's testimony and Mr. Haig's, Michael Haig's excluded testimony. So Defendant's 93 for record purposes only. I believe that Mr. Hermans didn't have an objection.
No. All right, they are admitted for record purposes.
And also, Your Honor, in addition to the objections that are in Defendant's 93, I also want to renew the objections to the exclusion of Mr. Haig's testimony and the excluded parts of Ranger Armstrong's testimony under the compulsory process clause of the 6th Amendment and the due process clause of the 14th Amendment. Just ask the court for a ruling on that.
Overruled.
Thank you.
Okay. And before we bring the jury in, I think, Mr. Rogers, you wanted to qualify your other expert.
Yes, Your Honor. Craig Miller.
Or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please make yourself comfortable.
Judge, I offer Defendant's Exhibit 94, which is the CV of Mr. Miller.
Thank you.
For record purposes.
You don't have any objections, do you, Mr. Holmes?
No, Your Honor.
It's admitted for record purposes.
And Judge, I don't think our fight, I don't want to speak for Mr. Hermans, but our fight's going to be over qualifications in general, but I'm just going to point out a few things. You have the CV, and then get straight to his opinions. That's okay.
That's fine.
Please introduce yourself and spell your first and last name.
My name's Craig Miller, Craigmiller.
And how are you employed?
I'm currently retired for my second time.
And what's your current profession?
I work as a testifying expert witness in police use of force, civil rights cases, as well as a security consulting firm that I own doing school vulnerability assessments.
And the judge has your CV, but I just want to point out a few things. You worked for the Dallas Police Department for how long?
Nearly 30 years.
And you achieved up to what rank?
I came through the ranks. I was a deputy chief when I retired in 2011 over the Crimes Against Persons Division, which oversees the 180 criminal investigators who cover homicides, sex assaults, robberies, and the CSI function for the 1.3 million people in Dallas.
And were you also in different supervisory roles for lieutenant with the Crimes Against Persons Division?
Yes, prior to being appointed as a deputy chief, I was the homicide commander for the Dallas Police Department from 2007 to 2010, during which time I oversaw 750 murder investigations as well as 75 officer-involved shootings that I was at the scene of, where more than 100 officers discharged their weapon.
And after leaving the Dallas Police Department, what was your position?
I retired to take the job as the chief of police for the Dallas Independent School District Police Department, and I retired from that position this past March 2019, after my 8th school year.
And have you testified in federal court as a use of force or use of deadly force or police practices expert?
I testified in federal court this summer in Austin and in Dallas. Yes, sir.
Have you been designated as an expert in state court as well?
I have. Yes, sir.
Mr. Miller, have you also been through the force science certification course?
I did. In 2015, I attended the 40-hour Force Science Institute training course.
And can you tell the judge what that is?
Yes, sir. Force Science is a research-based scientific institute that deals with determining human behavior regarding deadly force confrontations involving police officers and the science behind the actions that the officers took that's research-based.
And did I ask you to apply all your experience, your training in looking at the case involving Mr. Jean and Amber Guyger that occurred on September 6, 2018 and make some conclusions?
Yes, sir, you did.
Can you tell the judge your opinions as to the reasonableness of Amber Guyger's actions once she stepped into apartment 1478 on September 6, 2018?
Yes, I use the same methodology when I approach these as I did when I was with the Dallas Police Department, as well as I teach officer-involved shooting class. I've taught in 4 different states this year. And when I look at that, I try to look at the totality of the situation. Obviously, I use, because I'm from homicide, I use a victimology type approach, which I want to go dealing with both the suspect and the victim in the case, or the person, the witness, and the victim in the case. I want to know what was going on with them in those moments, and including days up to the incident. I certainly consider that information because that's a part of the investigation that I look at. But in conducting a criminal investigation, I really try to focus on that time and that moment in time when the actual force was used. So in this case, I really focused my emphasis on that time in the doorway. I considered all the evidence that you provided to me leading up to that point. But it's that moment in time when she's at the threshold of the doorway that I'm most focused on with regards to my opinions in this case. And in using that, I tried to use the principles that I've learned as well as the principles that I teach. And that deals with the first thing that I think you have to look at is something that's called in science, it's called inattentional blindness. Inattentional blindness. It's the tendency of the human brain to filter out visual images that are not relevant to the primary target. I think in police work this is really important, but it's also inattentional blindness is something that's consistent with people. It's not specific just to police officers. And so in looking at that, this is why people want to know, well, how did the police officer miss an item? How did they not see this? Why did they not see that? And it is because their attention is so focused on that object that they're looking at. So I look at that in conjunction with a process that police officers go through. They must observe they must orient, they must decide, and then they must act. This act is a point I call the go, no-go point. And that go, no-go point is when they elect to use force against that person that they feel the force is necessary to be used against. And so I try to use that formula as my basis for why the shooting took place, and then I look at that information.
And were there other dynamics that are occurring in the shooting that you look at that you've seen in your 750 plus homicides and 75 plus officer-involved shootings? Science and your training and experience?
I think the thing that I really try to look at is that it's really simpler than it comes out to be, and that is the timing in conjunction with the movement. In this case, we know that based upon the testimony that I've seen, that Ms. Guyger places herself at the door with her left arm extended, with basically holding the left door open, that her left arm used to hold that door open. And then she is, the time that she shoots the bullet in conjunction with the movement of Mr. Jean is what I try to focus on. And in doing that, I see that she is moving against that door with her arm extended. And I think it's important to note that in my experience as a police officer, 37 years, that when myself as well as other officers that I see at the pistol range and I see in qualifications, both in the school district and well within Dallas Police Department, that the first shot where there's no recoil is generally speaking the most accurate shot that a police officer will shoot. It's after that that the recoil starts when I see that a little bit of wavering with regards to the accuracy of the officers. So I try to keep that in mind when I'm looking at this. And then I think about the movement of Mr. Jean in this case and where he was. And I've heard the testimony, and I'm not going to get into the distances. I want to just talk about the fact that I think it's logical that if a person were in their apartment and someone opened their door, that they would want to know who that person was. And if Mr. Jean was able to determine that Ms. Guyger was extending a gun, pointing at him, I think it's logical that he would duck. Duck and cover is a very common thing that I think every person does when faced with a situation. And it's my opinion in this case that that's what took place.
And did you form an opinion as to whether the defendant, Amber Guyger, her use of deadly force was reasonable on September 6, 2018?
Yes, sir. I think based upon the facts, the totality of the facts that were involved, when you look at the inattentional blindness and what she was looking at, and you look at that loop that the officers' minds are going through with regards to that, and then the time that's available, because you have to realize that a person can pull their hand up and move their hand or their forearm up to a 9-degree angle in 12/100ths of a second. That's research-based empirical data. They can then lower their arm in 1800ths of a second. So this is going on faster, and all this is going on in their loop, in their brain. And it's my opinion that in this case, that Ms. Guyger, thinking she was in her own apartment, fired a shot at a person that she felt was a threat to her, and that was reasonable.
And with regard to your opinion that it's consistent that someone would duck when faced with a firearm, and the angle of the shot, the wound pattern we see in this case, is it consistent with your training and your experience and the research that you've seen that the position of the body when she makes the decision to fire the bullet versus the position of the body when the bullet strikes the body?
Yeah, I've been to hundreds of murders, and I've seen bodies fall in directions that I didn't think that they were capable of getting to. But in this case, I think it's very reasonable that when the duck and cover takes place regarding John, that in conjunction with the movement of Ms. Guyger against the door where they're all extended, that the path of the bullet would quite likely go that direction.
I'll pass Williams.
Good morning, sir. First and foremost, can you tell me what is your definition of reasonable belief?
Well, the Supreme Court says there is no definite answer to what is reasonable belief or reasonable use of force. In my mind, it is that definition of what a reasonable police officer would do when faced with that same set of circumstances in a tense, uncertain, rapidly evolving situation.
Right. And so, and I've read a lot of your transcripts and a lot of your expert opinions, and that is very consistent with your approach in the past, that you take your position or your basis of expertise when you are judging a case is based on a reasonable police officer standard in the circumstances.
That is correct.
And you rely, and you also noted that was from the Supreme Court. You're referring to a case called Graham v. Connor, correct?
I am, yes, sir.
And that is specifically the marker by which you apply use of force situations and reasonableness. in every one of the opinions that I've read that you've offered to a court before.
Yes, sir, that is the standard for law enforcement.
And that's the standard that you're using today, in your opinion, correct?
Yes, sir.
Okay. All right, so let me just do this. You want to testify about two things. Mr. Rogers went through the methodology that's going to be the basis of your opinion, or the background of it, but again, you want to testify as to two opinions. Number one, that you believe, that Craig Miller believes that Amber Guyger was reasonable in her decision to use deadly force.
That's correct.
Okay. And the other opinion that you want to offer is that you believe, Craig Miller believes, that Amber Guyger believed that she had to use deadly force.
Well, in assessing officer-involved shootings, I obviously am not Amber Guyger, and I can't put myself in her position. The actions of Amber Guyger are consistent with what I actually saw in working 75 officer-involved shootings involving more than 100 officers, as well as my training around the country. The force that she used when faced with the situation she was faced with was appropriate.
Okay, well, because, Mr. Miller, you said on direct that your opinion was that I feel Miss Guyger felt that she was in her apartment and shot when she reasonably felt she was in fear. Is that your opinion?
Yes, sir.
So your second opinion then is going to be that you believe that Miss Guyger believed that deadly force was immediately necessary.
That's correct.
Okay, so that's going to be the two opinions that you want to offer the jury. That it is your opinion that deadly force was reasonable, and it is your belief that she believes that deadly force was immediately necessary.
Well, those are two of the things, but I'd also like to talk about the inattentional blindness and what that means, because I think that's important for the jury to understand what police officers as well as regular citizens are faced with and why they're inattentionally blind to things other than what they're focused on. So I think that's important for the jury to know.
And that was but that's one of the bases of your opinion, correct, is the reasonableness.
Yes, sir.
All right, and for inattentional blindness, you said that these are principles that you have learned. What exactly are you basing? What is the basis of your understanding of inattentional blindness specifically?
It is the tendency.
I'm sorry, I wasn't clear. What information source are you relying upon as your educational background when it comes to that particular word?
Well, the Force Science Institute, and then the many articles that I've read on that with regards to the cases that I'm currently retained on and the cases that I've been retained on in the past 7 years.
Okay, what articles specifically?
One I have in front of me talks about, it's a Force Science article titled The New Invisible Gorilla Study Aids to Proof of Inattentional Blindness. That's the one that I have before me today. I've read hundreds of articles on this, but I don't have them with me, and I can't recall the exact names of those articles or when they were published, Mr. Hermes.
So your reference for today, although I don't doubt that you've read other stuff before.
Yes, sir.
I mean, obviously, I can't voir dire you on stuff that you can't provide to me as the basis of your knowledge. So I don't know whether or not in these other articles they're legit or they're bogus. I don't know if they were peer reviewed. You don't know any of this stuff to confirm whether or not the information is accurate.
I'm sorry, sir. I would probably disagree with that because I believe that the basis of Force Science is that things are empirically peer-reviewed, and Force Science talks extensively about inattentional blindness.
Sir, I think you will have to agree with me on this. Force Science is not without its detractors and critics. Force Science has been widely criticized by a number of people for its forensic and foundational basis. It is not accepted gospel. You have to agree with that.
No, sir, I wouldn't agree with that because I believe that literally every single year, hundreds of police officers attend force science training. I believe that your people at the Dallas County District Attorney's Office, people in the Public Integrity Unit have attended the force science training.
Absolutely, sir. I'm not saying that all information from a variety of sources is good to have, but you're suggesting that force science it is without detractors. And, for example, have you ever heard of Lisa Fournier?
No, sir, but I agree with what you're saying, Mr. Hermes, that there are detractors to force science. I'm not going to disagree with that point at all, but inattentional blindness is not just a force science analysis. Inattentional blindness is something that is scientific in nature for not just police officers, but every person in this room, every person alive has experienced in some way, shape, or form inattentional blindness.
Well, but that's going to be my second point. But before I got to that, I just wanted to ask you what your basis of knowledge was, and what you've offered me right now is one article that was in a magazine. Is that right?
It will be for today, yes, sir.
Okay. And can you tell me whether or not that article has been peer reviewed? Can you tell me what the research, what the research criteria was, the number of people who were involved in that particular study? Can you give me any kind of indicia of reliability and veracity for what it is that you're reading?
No, sir, I cannot.
Also, have you been the lead investigator in an officer-involved shooting?
Well, when I was in the crimes against person and I was the homicide lieutenant, we did it different than they do it today. We obviously always had a lead investigator who would be assigned in the case, but I was actively involved in the investigations and the interviews of the officers. So when you ask me, have I been the lead investigator? No. Was I present at the scene? Yes, sir. Was I involved in the interviews with the officers? Yes, sir. Was I at that point involved?
So you're not just asking if you were the lead investigator in an officer-involved shooting?
Yes, sir.
Okay, is the answer no?
It is correct.
Okay. Then I wanted to also ask you, when it comes to this...
Or you have not been the lead investigator?
No, ma'am. When I was in Capers and SIU, and I was in charge of SIU.
You supervised other officers that were the lead investigators?
That's true, but we did it a little bit differently back then, where there was, like Detective Ibarra, who's been here, would have been the lead detective. When we went to the scene, at that time we did a walkthrough in the field. I would many times lead that walkthrough in the field. When we came back to the office, and we would sit down with the officers and their lawyers, and they would be preparing their statements. Many times I was involved in the questioning of the officers. So whether I was the lead detective, I was actively involved in the investigation and not on the peripheral watching in, just approving things.
I'm sorry, Mr. Hermes.
No problem, Judge. I want to go back, though, to at least the one issue that I was talking about, Lisa Fournier, Fournier. Are you aware that, at least at the time of this quote, that she was an editor for the American Journal of Psychology and a professor at Washington State University? Have you ever heard of her, sir?
No, sir, I have not.
And concerning her opinion of the force science structure and classes, she indicated that it was pseudoscience and lacked basic elements of legitimate research, such as control groups, and drew conclusions that were unsupported by data. So that is a contrary view, would you at least agree, of at least one aspect of your expertise?
Yes, sir.
Your opinion of force science.
I would agree with it.
Okay. So when it comes to inattentional blindness, and then I'll also cover this too, just we're going to assume for the purposes that it does exist. You're not going to testify that it exists in every case, is that right?
No, sir.
Okay, so in any given case, including in this particular case, whether or not there was inattentional blindness, you don't know for sure.
No, sir. In my experience with police shootings, having been there with the officers in the field, I think their memory recall and how even officers standing beside one another, where one officer would draw their gun and shoot a suspect and another officer never draw their gun, and then you say, what did you see versus what you saw? I find that consistent that police officers don't see things the same way. And so I see that that's the norm, that police officers from memory and recall, when faced with stressful situations, act the way they do.
But what I'm talking about is inattentional blindness. Isn't it true that that will vary on a very individual basis?
That is correct.
And you don't know what degree Miss Guyger, if any, had any inattentional blindness.
No, I'm not Ms. Guyger, and I cannot speak for her. I can speak to how my experience with police officers was and inform the jury that it is a real phenomenon, in my opinion.
Right. But again, you would have to say that that occurs. Some, all, or to no effect.
Yes, sir.
It varies.
Correct.
So it would be pure speculation based on what you may have experienced or what other people may have experienced, and how that might apply in this case.
I don't think a person that's been to as many police shootings as I've been to and been to as many homicides as I've been to would call it speculation. It's not just something that I've read in a book and that I've researched. I've actually seen it and experienced it, so I think it is much more common perhaps than you might suggest it is, Mr. Hermes.
Sir, I'm not making a comment on whether or not it's common or not. What I'm saying is going to be pure speculation on your part to gauge whether or not Ms. Guyger had any attentional blindness, or to what extent.
That is correct.
Okay, that's the point I'm making. Who can testify and who can impart any kind of degree of inattentional blindness that Ms. Guyger would have experienced?
Ms. Guyger.
And you know Ms. Guyger has testified.
Yes, sir.
Okay. So again, just to be clear, you want to offer testimony concerning the reasonableness, that it's your opinion that the shooting was reasonable, and it's your opinion that Ms. Guyger believed the shooting was reasonable. Oh, and yeah, and then you also, you had offered some evidence, or you wanted to give an opinion that Botham Jean was ducking at the time of the shooting.
That is my opinion. Yes, sir.
Okay. What are you basing that opinion on? Because you heard Ms. Guyger's testimony.
Ms. Guyger, when faced with inattentional blindness, is focused on an object that she sees in the background, that she sees shuffling, and she's focused on hands, because hands are what we know as police officers can hurt us. I feel it's logical that Mr. Jean, or in this case, or a person, when someone was pointing a gun at them, would duck and cover. I feel that's logical.
So you've seen people who have been shot before many times straight in the chest, correct?
I have.
In the head.
Yes, sir.
In the back.
Yes, sir.
These are people who were presented with firearms. Firearms were presented against them.
Yes, sir.
They didn't duck.
I would disagree with that. I have seen people duck. As a police officer, when I've been shot at, I've ducked.
There are circumstances, Mr. Miller, of course, where people have ducked. But those circumstances, like everything else, the way in which a person is shot, they vary on a case-by-case basis.
Absolutely.
All right, and so, again, when it comes to ducking, that is a guess that you are making based on something that might have happened, in your opinion, that would be logical.
That it's a guess, yes, sir. There's no one will know that. That is consistent for me in my looking and reviewing this case as to the path of the bullet.
Sir, you don't know what the path of the bullet is. The medical examiner can testify. You weren't there for the autopsy, were you?
No, sir.
All right, Your Honor, that's all I have. I'll pass the witness.
Did you have more questions, Mr. Armstrong?
Oh, Your Honor, I did have one other question.
Go ahead.
Mr. Miller, I was also looking at some of your previous testimony. You told the judge that you had testified in federal court before, is that correct?
This summer I testified in Judge Sparks' court and I testified in Judge Lynn's court.
Right, and so you remember testifying in Austin in 2015, is that correct? In Orr v. Copeland?
I did not testify. I wrote a report.
Okay, do you remember at a pretrial hearing concerning what you were going to be allowed to testify to, the judge forbade you to testify as to any legal conclusions, including whether the defendant's use of force was reasonable?
I'm sorry, sir, but I wasn't at that pretrial hearing, so I don't know what all the city attorneys in Austin argued or were presented with.
Do you agree, or do you have any reason to doubt that the judge in the order was not going to let you testify as to what your opinion was on reasonableness?
I just don't know that, sir.
That's all I have.
This summer, you testified in Judge Lynn's court,
I did, yes, sir.
or were you allowed to testify as to the reasonableness of the officer's actions in a deadly force
I absolutely was, yes, sir.
in Judge Sparks' court in Austin?
Yes, sir, I was allowed to testify to the reasonableness.
With regard to inattentional blindness, you don't have every study that discusses that. There's probably thousands, but is that a concept that is widely accepted in your field?
Yes, sir, it is.
And with regard to the rest of the opinions that the basis of your opinions, are those all that widely accepted in your field of use of force applications?
Yes, they are, and I teach them as well in my class.
And with regard to the position of the body, is it consistent with the studies and your experience that an officer firing the weapon can see the suspect or the person they're firing at in one position, and by the time the decision is made to fire, by the time the trigger is pulled, the body can change in milliseconds?
Yes, sir. Scientific experiments have shown that a police officer is capable of firing 4 bullets in 1 second. There's a reason why I think sometimes across the country people feel like officers shoot people in the back when in fact they were facing them. It takes the average police officer more than a half a second to be able for their brain to tell their finger to disengage, to stop the shooting action, which is as the person turns, they could still shoot them in the back. That's scientific data.
So that's your application of that data to consistent with your opinion that Mr. John could have been going from an upright position to ducking during the processing of the decision to shoot?
Yes, sir. Absolutely.
That's it, Your Honor.
Mr. Miller, I'm going to be very brief because that was also, you just talked about timing again. You understand the 0.56 seconds, you understand the study that is based on, it's called the Tempe study?
Yes, sir.
You understand that was also in a magazine and was not peer reviewed and is widely criticized and disputed?
Yes, sir. And I also realized it was in a sterile environment as opposed to a real life situation where people are under stress.
Exactly. It's just, its reliability is in doubt. Although the Tempe study is certainly something that is worthy of reading, it is not in fact accepted science throughout the entire scientific community. Agree?
Yes, sir.
I'm nothing further.
Well, I just have some questions because I'm curious.
Yes, ma'am.
Your inattentional blindness, you said that generally or oftentimes some officers experience it and that their focus is centered on the suspect. Is that correct?
It's the tendency of the human brain to filter visual images that are irrelevant to their primary target that they're focused on.
And one of the other things you also mentioned is that some officers can observe something and never draw their weapons, and others can observe the same thing and do in fact draw their weapon.
And shoot their weapon. Yes, ma'am.
And shoot their weapon. So I'm just curious, when or if someone is experiencing inattentional blindness, what of the suspect are they focusing on?
Generally speaking, it's going to be that person's hands, or if there's a weapon. If they have a knife in their hand, they're going to notice the knife. If they see a gun in a person's hands, they're going to notice the gun. But they're going to notice that part of that person they think can hurt them the most.
And how do you know that that is the center of their focus?
Well, from my experience in the shootings that I've been present at, that was their focus. And my research in reading articles on that's the focus in my training at the Force Science course.
So is there some scientific data that tells us what portion the shooter was focused on? Because I'm just curious, just for my knowledge, if you are experiencing an inattentional blindness, is it the movement of the person, or is it in fact their hands?
Well, they're really the same, ma'am, because the person is moving and their hands can be moving. Obviously, if I'm sitting here in this chair and my hands aren't moving, it's obvious. You know, you're going to be looking for me to come up like this. If it's in the scene, if it's dark, I'm going to be looking for something, and light's going to affect this as well. But I'm going to be focused on the part of that person, witness, that I think could cause me as a police officer the most amount of harm.
Is that generally what officers experience, that their inattentional blindness goes directly to the hands? Is that always or generally the case?
Well, I think really I'd like to describe it as more, it's the things that we kind of Monday morning quarterback in. Well, why didn't they see this? Or why didn't they see this? Or how come they could have missed this? In my mind, it really goes more to that whether it's specifically the hands or the movement of an object in the background that they're focused on, in my mind, in my experience, it's these ancillary things that are out here, that are out here that they're not seeing, and it's this object that they're focused on that they're seeing.
The other thing that I'm curious about is the information that you have imparted to us, the officers observe, orient, and act to decide go or no go. Have you conducted similar studies with officers who did not shoot, or are these limited to officers who actually fired the weapon?
Well, I can speak probably firsthand from that, because as a police officer, I've been in many situations where I could have shot and I didn't shoot.
I know, but I'm talking about all the training and experience that you have. Is it equally balanced with decisions to not shoot that were made?
Yes, ma'am.
Or are we focused solely on officer-involved shootings?
No. Well, I do focus on officer-involved shootings, but are you talking about homicides? Or
You talked a lot about officer-involved shootings, so I guess the crux of what I'm trying to find out is there any information out there on the countless times when officers do not shoot? Or do we just look at when they have shot?
No, ma'am. I think that we have to look at the totality. I agree with you completely.
Are there any studies
Oh.
that we can look at to see, even when they did not shoot, was there an inattentional blindness going on?
I think probably embedded in all of these studies, when you look at the empirical data, that there are officers that didn't respond as quickly, or in many instances didn't shoot. So that is a part of the data, but don't really have that with me.
Well, I don't pretend to be an expert in this area, but just in trying to read up on this, I've been trying to look for other studies, just wondering, and I thought you might know.
No, ma'am.
I'm just wondering. So let me just be clear. You believe that you have the expertise, training, and experience to discuss what an officer's focus might be on at the moment in time when they make the decision after having observed, oriented, and decided to shoot or not shoot.
Yes, ma'am.
And you can describe generally that some officers may have an inattentional blindness. Correct. But you don't know whether or not Ms. Guyger experienced that, and nor am I going to allow questioning in that area if we go forward with this.
Yes.
You can't say with certainty what her experience was, because you did not live her experience.
Exactly.
And as you testified, there is no reasonableness. So you don't know Well, stop. Let me stop. Are you both concluded with your question?
I am, Your Honor.
Yes, ma'am.
Are there any objections to Mr. Miller's testimony?
Judge, I do object. First and foremost, I think Mr. Miller has applied the wrong standard. He has applied the Graham v. Connor standard, which is the standard for civil rights actions under 1983 in federal courts for money. It is not the standard in Texas criminal courts. So his entire opinion is predicated upon a standard which is wholly and totally rejected for purposes of criminal cases in Texas.
So you object to Mr. Miller proffering an opinion as to whether or not he believed the defendant acted reasonably?
Yes, well, certainly as to reasonableness, that he applied in any context, reasonableness on any level, because he's applied the wrong standard. Secondarily, he's already conceded on my voir dire that he would be basing, or his opinion would be based on his opinion of reasonableness, which is not of any assistance to the jury because the jury is fully capable, using the appropriate law that governs this case, to make a determination of an ordinary, prudent person at the time of the situation. They are capable of doing that, Judge. All that Mr. Miller, because of his very commendable resume, all that allowing him to give his personal opinion does is it invites the jury to supplant their well-reasoned opinion, independent decision as jurors with his. That's not appropriate. Secondarily, Judge, his opinion that Amber Guyger believed is reasonable goes to his testifying as to her state of mind, which is not allowed. No expert is allowed to testify to the state of mind of the defendant at the time of the offense. Ms. Guyger has testified. The jury has been made aware of what her state of mind was. So I certainly disagree with both of those. Your Honor, I would object to, I think that just based on what I've captured from your statement already, that the rank speculation of ducking would not be permitted. I completely object to that. That is, first of all, that is wholly inconsistent with the testimony from the jury from the defense's case. Secondarily, it is based on Mr. Miller's belief of the path of the bullet in the body, that he never did attend the autopsy. He's got there's no proffered medical background. That would just be pure speculation. He's admitted that there's been hundreds of shootings he's been involved in where persons have ducked, haven't ducked, given a dynamic variety of situations. I think that is pure speculation. I would ask that that not be allowed. With respect to inattention blindness, as long as there is no testimony specific to Ms. Guyger or no testimony that it happens in some sort of statistical number of cases, if it's just going to be testimony as far as generally this could be something that could be experienced, I think the court seems to be willing to allow that. I don't really know if I have any objection of that. I do think that that is also speculation, but nevertheless, if it's just going to be offered that it may be a possibility, I suppose that is going to have to be something we accept. So those are, I would certainly object to any kind of testimony that would ascribe some sort of degree of inattention that Ms. Guyger would have experienced in this particular case. Again, I think that only Ms. Guyger can say that, and she has. As far as shoot, no shoot decisions, I actually was going to argue based largely, I think the court also picked up on this. Mr. Miller is talking again anecdotally about his experience of shoot, no shoot without any kind of a basis of any scientific studies which gauge it, other than to say that he's been to the range a lot. And yes, there may be information which suggests in a shooting situation, the shoot decision or the no-shoot decision. But there is no information before me or before you that talks about probably the vast more decisions where officers don't fire at all. So that information, I think, is also without any kind of scientific or reliable basis, which means that it should not go in front of a jury, when all it does is just throws speculative possibilities in front of a jury without any kind of basis upon which the jury could actually use it in a productive way. So I object to anything other than perhaps just a general belief that inattentional blindness may occur and that the focus may be on the threat.
Yes.
First of all, with the Mr. Miller's articulation of the reasonableness standard, he is discussing the reasonable standard set down in Fourth Amendment jurisprudence in 1983 excessive force cases by the Supreme Court, and how the decision on whether a suspect's Fourth Amendment was violated, whether excessive force was used, is that of an objectively reasonable officer facing the exactly same set of quickly evolving, dynamic, tense circumstances and the decisions made when the trigger is pulled. And that hindsight is not 20/20 hindsight is not how you look at it. You look at it from the perspective of the officer and whether the officer was reasonable when the force was used. And that's what I've asked Mr. Miller to do, look at it from the perspective of Ms. Guyger in this case, based on all the discovery, the autopsies, the body cams, and the testimony that he's witnessed in court. To say that it's been rejected in Texas criminal case law, I don't know of a case that has specifically rejected it. I'm not aware of that. I understand we're looking at an ordinary and prudent person, but there's Mr. Miller can make that distinction, that how he looks at it, how he analyzes it, and apply it to the ordinary and prudent person standard, if you allow him to get into the reasonableness of his conclusions that he believes that the deadly force was reasonable. Not specifically that he believed that Amber Guyger believed the deadly force was reasonable, but his assessment that the use of deadly force in this case was reasonable. With regard to the observe, orient, detect, act, that is, you don't have to have a scientific experiment for every opinion that someone offers in the courtroom. He is qualified as an expert. This is the observe, orient, detect, act. That's something that is triggered in every tense, dynamic situation that an officer faces, and Mr. Miller can apply that knowledge that's applied widespread in police practices and procedures. The field of expertise that Mr. Miller has is legitimate. The subject matter of his testimony is within the scope of that field, and his expert testimony properly relies upon or utilizes principles involved in the field. He doesn't have to have every scientific study that's done to apply his 37 years of experience in addition to his training. And under 701, 702, 704, we proffer and pursuant to Nino v. State and the case law in Defendant's Exhibit 93, we would proffer Mr. Miller for those opinions.
Mr. Miller, you do have a distinguished and glowing career, and I commend you for that. The court will allow you to testify as to the inattentional blindness and the principles of observe, orient, detect, and act. However, there will not be any testimony as to whether or not you believe the defendant's actions were reasonable, or whether or not the defendant believes that her actions were reasonable, nor will there be any testimony concerning the movement of the complainant. As you testified, it's a logical conclusion that one might believe that the complainant ducked and took cover. And inasmuch as it's simply a logical conclusion, if that's the conclusion the jury wishes to reach, I don't believe they need experts to tell them that. Well, I'm not going to allow any testimony from you or any other persons that the use of deadly force was reasonable. That will be for the finders of fact to determine. And I don't believe that it's appropriate that we use the reasonable police officer standard. But that being said, are we clear on what the area of his testimony may be?
Yes, Your Honor.
Okay.
Yeah, Judge, one matter of clarification again, are you going to allow the testimony in a general sense?
Generally.
Okay, so
Not
no,
specific.
not specific to Ms. Guyger.
Correct.
And
Make your objections.
further object that the excluded testimony violates the compulsory process clause of the due process clause of the United States Constitution.
Overruled. Okay. Do you all need a break before we bring the jury? Okay, we'll bring them in and take it to the panel. Thank you. You all may be seated. Good morning, everybody. Thank you all for giving up your Saturday for us. Mr. Rogers, please call your next witness. Ranger Armstrong has already been sworn, and I'm sure he's aware he's still under oath.
Yes,
Make yourself
sir.
comfortable, sir.
Ranger Armstrong, the members of the jury have already met you. I'm not going to go through all of your qualifications, but just in summary, you've worked with the Department of Public Safety. In addition to the academy, you've been with the Texas Highway Patrol, SWAT, and the Texas Rangers, correct?
That's correct.
And currently, are you assigned to a tactical unit?
Yes, I am.
And what unit is that?
That's the special response team.
And what do they do?
They do similar tasks as a SWAT team. The SWAT team for DPS is a full-time team, which that is their only job. The SRT that I'm a part of is a collateral duty team, which means I still do my primary ranger responsibilities of investigations. In addition to, when needed, I perform tactical tasks with the SRT.
And so, in line with your training and experience throughout the Department of Public Safety, and can you tell the jury generally about sensations that a person might experience when confronted with a quickly evolving, tense, dynamic confrontation with a suspect?
Sure. Some of the physical sensations that might be felt by somebody experiencing a scenario, as Mr. Rogers put, would be auditory exclusion, which basically means that you may not hear at the normal volume that you normally would because you're under stress. You may have vision narrowing or tunnel vision, which means you are only focusing on what is directly in front of you, not in your periphery. You may also experience short-term memory loss, which may be regained over time because your mind is prioritizing tasks at that moment in time. And the last one that you may experience is also a rapid heart rate, which may increase to a very elevated level due to the stress that you are experiencing mentally, physically, and psychologically.
I'll pass away.
Where's the witness, Judge?
Yes,
Ranger Armstrong, I'm going to show you what the marker identification is. States Exhibits 321, 322, 323, and 324. Starting with 324, do you recognize that as being a still picture off of Officer Wynn's body-worn camera?
Yes, I do.
And that's going to be a fair and accurate depiction of the officers giving CPR to the complainant while they were in 1478.
Yes, that's correct.
And then 321 through 323, are those going to be fair and accurate depictions of the shorts being worn by Mr. Jean at the time he was shot after they had been received and photographed by the Dallas County Crime Lab?
Yes, sir, that's correct.
All right. Your Honor, I'm going to offer states 321 through 324.
They're all admitted.
Ranger, Mr. Jean had no pockets in his shorts, correct?
That I cannot answer.
Let's see the pictures.
Sure.
Front view, sort of side and side view.
And you said no pockets?
Correct.
That's correct. It doesn't appear to be.
Pass the witness.
Nothing further, Judge.
May the ranger be excused?
I'll have him stick around, Judge.
Okay. Thank you very much.
Yes, Your Honor.
Take no reproach.
Yes. You all may just sit here. So I'll check that with you at like 10:35 with you all.
Yes, ma'am, I'll be here.
Okay. An attached portion of the transcript. She's going to have an opportunity to make an official transcript to attach. She can't attach the unedited part. So I just want you to know that it's not going to go in until she makes the official record.
Okay.
And then I guess she'll let you see it.
Sure.
Stick it on the
Bye.
Okay. Can I see you guys over here? Can you unlock the door? Miss Chief? All right, you may be seated. Ladies and gentlemen of the jury, you've heard all the testimony that you're going to hear today. I'm going to ask that you be back here on Monday at 9:30 and we'll resume court at that time. I'm going to give you the same admonition. I think you all probably could repeat it with me. I'm not sure whether there'll be media coverage or not, and you should not be accessible to it, but if perchance, don't read it, watch it, or listen to it, or don't allow anybody else to talk to you about it, okay? I'll see you all Monday morning at 9:30.
All right.
You all may be seated. See how good people. Monday morning, well, I'd like to talk to your attorneys right quick, and then I guess the rest of you can retire to your homes. Off the record, Ms. T.